Joining us here on India Business Hour now is Rana Kapoor, the Managing Director and CEO of Yes Bank. Thanks, Mr. Kapoor, for joining us here. My first question to you, how are you reading this verdict? We see it as a setback. While you can continue as the MD and CEO, you have lost some power, with Shagun Goguyana also having a call as far as the appointment of directors go.
I'm actually amazed at this observation and equally amazed at your question, because if you see the release which has been made by Yes Bank as approved by our senior counsels, as approved by our solicitors, Cyril Amarchand, Mangaldas and company, you will see from the announcement that we have just made, and every word is an extract of the overall judgment passed by the Honorable High Court in Bombay. If you see the moot point that the Honorable Court has made, one, that the articles of association of Yes Bank, because they are dated, they go back to 2003-04, that they need to be updated to reflect the current needs of the organization. That's point number one. Point number two is that the main contention of the plaintiff, which is Madhu Kapur, and her family, particularly her daughter Gogia, her request, which was turned down by the board earlier, has now been affirmed by the Honorable Court as the decision of the Board of Directors is full and final in this respect. So it has been upheld, the decision of the Board of Directors has been upheld by the Honorable Court. Number three.
If I may, I'm sorry to interrupt you, but this is Menaka here from CNBC TV 18.
Yeah.
And I just did want to point out a couple of things that I'm reading right out of the decision or the judgment of the Bombay High Court, which in a sense says very clearly that the right to appoint directors is a joint right. It is not a right that either party, your side or the Madhu Kapur side, can exercise individually. It is indivisible, and therefore it must be exercised jointly. And keeping that in mind, the court has also therefore found the nomination of 7 directors to be null and void, except that it has stayed that part of the order for 5 weeks from now. So I suppose the material question to put to you would be, what happens to the fate of those 7 directors? Do you hope that you would be able to mediate a solution with Madhu Kapur and Shagun Gogia, whereby the stability or the operational stability of the bank is not hurt?
Monica, it's a very one-sided and very unfair question that you're raising on a prime channel, because I think you need to understand that since Mrs. Madhu Kapur and her family took action against the bank and all its directors without exception, in the last 2 years, there have been 3 AGMs of Yes Bank, and in every AGM, all the directors whose appointment or reappointment has come up have been elected with an overwhelming majority without exception, number one. Number two, all business resolutions without exception have been approved by overwhelming majority. When I say overwhelming majority, it excludes just about only Mrs. Madhu Kapoor's shareholding, and almost all the other ownership in Yes Bank, which is fairly diversified, has voted 100%, almost 100%, along with the board of directors and the management.
Mr. Kapoor, I'm not disputing any of those things.
No, I know.
I'm simply reading out from the order.
No.
I'm simply reading out from the order. It says that...
Order is a very fair order. You should understand that 10% shareholder, which is what Mrs. Madhu Kapoor is, cannot decide the appointment of directors.
So I am simply reading out from the order. The order says that the right to nominate directors is a joint right. I'm not reading anything which is not in the order, sir. And therefore, the order also says that these 7 directors, their appointment is null and void, but there is a stay on that for 5 weeks. And therefore, I'm asking you...
No, your question is highly twisted.
How is it twisted, sir? This is what the order says. If you would like me to read out portions of the order, I can happily do so.
I will read it out louder than you. Let me tell you, there is no null and void. You read it yourself, that there are Mr. Ajay Vora, and as far as Mr. Arun Nanda is concerned, they have got elected in the board AGM, so that is infructuous, number one. Number two, the whole-time directors are only proposed. They are not yet been inducted on the board. So there is no impact whatsoever. the judge, the honorable judge, has categorically stated that any infirmity vis-a-vis two of the directors and non-consonance with any of the procedures laid out need to be corrected, and the bank has ample opportunity to correct that. None of this is null and void. This is a mere exaggeration on part of CNBC. I'm sorry to say that.
If I may read out from the order, sir, because I did not intend to make this confrontational. I was simply asking what happens here on. But I will read out from the order. It says both Rana Kapoor and Yes Bank have chosen to adopt a course that is unsupported by the articles or any fair reading of the relevant statutes. How is this unfair, sir? I'm reading from the order.
You know, you should read in the order.
I am reading from the order, sir. This is page 130 of the order. 13.5. That's the relevant paragraph that I'm reading. This is exactly what it says, sir.
Let me give you the exact quote-unquote comment here. It says that Yes Bank to take necessary steps to revalidate, appoint or reappoint the persons in question, and there are only two where there is some procedural infirmity subject to them meeting statutory requirements of the courts, including age limits. And age limits, by the way, have been approved by Reserve Bank of India. So there is no finding of disqualification of any of these directors for want of ability or credentials. This is the Honorable Court's response.
I did not at all imply that any of your directors were found short of credentials. All I'm saying is the Bombay High Court, and again I'll read out for you, sir. Paragraph 12.8 says, defendant number 8 cannot have been validly appointed as a representative director.
You're a very erudite senior journalist. Don't read only what is spicy.
I'm reading what's in the order, sir. I'm not reading it. I'm reading his conclusion.
Read the facts which have been announced by Reserve Bank by a board of directors, which have been released.
But sir, you would admit that reading just a Yes Bank release as opposed to reading from the Bombay High Court order itself would not serve the purpose. I'm reading from the Bombay High Court order.
We are a leading institution in the country. Our press release is vetted by two of our senior counsel.
Mr. Kapoor, I'm not disputing the facts of your press release. I'm simply asking.
And by our solicitors, and you are relying on information which is being
in the Bombay High Court order. I'm relying on information which is in the Bombay High Court order,
sir. You're relying on information. You're putting stickers on your channel which are completely incorrect.
How is it, sir? I'll read out paragraph 12.8. For the reasons previously discussed, defendant number 8 cannot have been validly appointed as a representative director or an independent director. His appointment is invalid. Similarly, the appointments of defendants number 10, 11, and 12 as whole-time directors of Yes Bank's board are also prima facie, ultra-virus, its articles and void.
I think you are exaggerating the interpretations. If you
Sir,
like,
this is a verbatim reading of the Bombay High Court order. Mr. Kapoor, it is not my intention to get confrontational with you. We were simply asking from the point of view of Yes Bank's investors. Will the board have to now be reconstituted?
In next 10 minutes, I'll get Mr. Cyril Shroff to respond to your interpretation. I will get Mr. Soli Cooper.
Mr. Kapoor, I will reiterate, I am simply reading out the Bombay High Court order verbatim. I am not interpreting it. I am asking you a question. Will your board have to be reconstituted, sir?
No, not whatsoever. If you see what I have said in my press release, as I mentioned to you, approved by my solicitors and the counsel to the bank, it is noted from the contents of the order, the impact of the operations of the Honorable Court's order is minimal on Yes Bank's board of directors. The reservations expressed by the Honorable Court have already been addressed in the ordinary course as mentioned above, and any further necessary procedural steps which are required will be taken in accordance with law.
So is it your view, sir, then, that the directors referred to in the order, they are currently, their appointment is not null and void, they will continue as earlier? Is that how we should understand this?
Madam Doshi, we had an AGM on 6th of June. The order is dated 4th of June. All the corrective...
Sir, the order is dated 14th of June, sir.
No. 4th of June, the order was finalized and announced today.
I am simply asking you, sir, if this board of directors will continue as is, or do you see the need to...
No change whatsoever. We will talk tomorrow and day after, next week and next fortnight. None of us are going away anywhere.
No, so I'm asking if you feel that at any point in time, any of these directors will have to be replaced by directors where you have also sought the consent of Madhu Kapur and Shagun Gogia.
No, they are, because please remember, these are independent directors who do not need my consent as the promoter of the bank, or for that matter, Mrs. Madhu Kapoor's consent, who's not present on the board, right? It needs the consent of the board of directors and unanimity. That's how corporate democracy prevails.
Mr. Kapoor, the Bombay High Court order also says the appointments of defendants number 10, 11 and 12, who I understand are 3 whole-time directors, is ultra-virus. And therefore, I'm suggesting I can read out their names to you: Rajat Monga, Sanjay Palve, Pralay Mondal. So I'm just asking you...
Manika Doshi, madam, they are not even on the board. Please verify your facts.
No, so these appointments, Mr. Kapoor, these appointments were invalid is what the board is saying.
These are proposed appointments. Proposed, please see my announcement. There were proposed announcements which need some rewiring, but it's not like they are board members. So why are you confusing your viewers?
I'm not confusing the viewers. I'm simply asking questions that you made it confrontational, sir. What happens here on?
No, this is, let's face it.
What happens here on?
As I mentioned to you, we have already given in my release, going forward, we have given the main 6 judgments of the Honorable Court. We have given the actions taken already since the order was contemplated on the 4th of June. We have already given the going forward statement. There are some minor course corrections required, which will not hamper a single of the 10 board members.
Do you
have to realize,
sir,
you have to realize
the need to mediate this any further with Madhu Kapur and Shagun Gogia?
You have to realize that the order is out and it has no setback for the bank. On the contrary, Mrs. Madhu Kapur and Ms. Gogia's claims have been declined in their entirety by the Honorable Court. Please highlight that.
So how has the claims been declined in their entirety?
For 2 years, this family has gained 4,000 crores of wealth from the board and its management, which was only 270 crores when Mr. Ashok Kapoor passed away in 2008. 4,000 crores of wealth, over 250 crores of dividends and shares sold. This is a very wealthy family, which is fighting a very flimsy case.
If I may say so, whatever is the family dispute, I'm only interested in understanding what happens to the bank board here on. Will it require both parties to nominate directors jointly here on? That's the message that the court order seems to send out.
This is a bank which is institutionalized. It is run by the board of directors. All policy, supervision, direction, all appointments are done by the board of directors. No family business is involved. In fact, if you see the statement made by the Honorable Judge, he says categorically that this is not a family turf, right? Please see this point as well, because, since you are so knowledgeable about this case, you should also see...
I am simply reading out from the order, sir. You are making this confrontational for no reason. I'm asking you if both sides will have to here on jointly nominate directors to the board. And you do have nominated directors on the board, sir.
That is not correct. There is not a single director today which stands nominated by me. Please remember that.
So
Get your facts correct.
Okay, so here on, Mr. Kapoor, are you saying that...
There is not a single director on the board of Yes Bank, including myself, which is nominated by me.
So here on,
please get your facts.
Try to understand the implications of this decision.
Manika, you are a very, very bright lady. Please
Mr. Kapoor, I'm simply trying to understand what happens here on. Do Madhu Kapur and Shagun Gogia have any say in the appointment of directors?
Sorry, no say is involved in matters of the board of directors. No matter, it says very categorically, it says here in point number 3 in a press release, apart from anything else, the demand for a seat on the board seems to be fly in the face of bank's ethos. It is said to be the professional bank. That necessarily means that it cannot run like a family estate. This is the Honorable Judge saying. and says, consequently, I do not believe it is open to the plaintiffs, which is Madhu Kapur and Gogia, to demand that any of them can take a seat reserved for them on Yes Bank's board.
So we fully understand, as we have put out as well, that there cannot be any board position for Shagun Gogia unless the board of directors decides to elect her as a director. We fully understand that. I'm simply asking, from the point of view of Yes Bank's investors and all stakeholders, that does this family dispute come to an end here? Or is there any other potential repercussion from here on in terms of how board of directors are nominated, etc.?
We have had a hat-trick of AGMs 2013, 14, 15, and the 15th. The third AGM was only as recently as 6th of June. All shareholders worldwide, almost equivalent of 90%, have voted for the professional decisions of the board of directors of Yes Bank. There's only one activist group which has 10.3%, which has personal interest and is overlooking the interests of 11,000 employees of Yes Bank and its 150,000 plus shareholders, including institutional shareholders across the world, right? And every resolution has been approved by overwhelming majority. It is in public domain.
Mr.
Please
Kapur,
see our press announcement.
if I may reiterate my question, sir, I fully understand all of what you're saying.
Yeah.
I'm simply asking. Shagun Gogia spoke to us earlier, and she seemed to understand this as a victory on her part and her mother's part, and therefore I'm asking you, do you believe that here on, any director positions will require the joint consent of both you and Shagun Gogia? Will there be any involvement of theirs in the nomination of directors to the board of Yes Bank or in any other decision-making at Yes Bank?
There is the only decision-making in Yes Bank relating to appointment of directors is vested with the board of directors, solely with the board of directors, and in two positions, particularly three positions, I would say, the appointment of the chairperson, the appointment of the MD and CEO, and appointment of whole-time directors, it requires additionally the approval of Reserve Bank of India. And all appointments require approval of shareholders. So you need to know that this is not some family decision-making.
I'm aware of that, sir. I'm simply asking you about the court battle and therefore what the implications are here on. That's all I'm asking, sir.
My answer to implications is contained in our illegally approved press release, which is no impact.
So you are saying that as per your interpretation, there is no future involvement of Shagun Gogia or Madhu Kapur in any operational part of the bank, including in nominating directors. Have I understood that correctly?
Absolutely. It's been rejected outright by the Honorable Court.
Well, that's your interpretation, sir, and there's her interpretation. We're not getting in the middle of this. I'm just trying to understand what happens here on with the bank.
We have a public statement in public domain.
There is no requirement for any further mediation, I understand, sir, from your point of view.
No, the order has been announced. Where is the question of mediation?
I'm asking if there is any further requirement, sir.
No, there is no further requirement. The order has been passed by the Honorable Court. We respect the order and we will adhere to the order in letter and spirit.
So as far as you're concerned, you're saying that this matter is closed now?
So as far as we are concerned, that the plaintiffs asked of what was impossible in terms of governance norms and in compliance with regulation, that has been declined outright by the Honorable Court. And there are one or two course corrections we need to make, and we have the next 5 weeks.
What would those course corrections be, sir? If you could elaborate on them, please.
I've already conveyed them to you. There are one or two procedural issues that we need to sort out, which are contained in our press release.
If you could just help me, because I don't have your press release with me, if you could just tell our viewers what those will be.
Which is why your questions are very one-sided. Kindly read it.
Sir, my questions are based on the Bombay High Court order. If you think that is one-sided, I can't do anything about it, sir.
No, you have to read the press release and you will understand that this has been approved by senior counsel and our solicitors, Cyril Amarchand Mangaldas, and therefore
Kapur,
all the
that's all very good. You said that there were some modifications that your side needed to make, and therefore I'm asking you what those modifications could be, if you could please elaborate.
The number one and the most important observation made by the Honorable Court is that the articles of association of a bank are somewhat stale because they were conceived in 2003 and 4, and that is our interpretation, and they need to be refreshed to give a new perspective to the articles in light of today's requirements of the bank. For example, whole-time directors cannot be decided by family members. They are decisions of the board. The MD and CEO is a decision of the board. The chairman is a decision of the board. Independent directors are decisions of the board.
So will you be, are you suggesting, sir, that you may consider, of course, based on shareholder approval, an alteration of the Articles of Association to take away the right of the promoter shareholders to nominate directors and allow for the board of directors to nominate future directors?
Well, please recognize that the late Mr. Ashok Kapoor was a co-promoter. He's no more. He's no more, and we have to respect that. That doesn't mean that the bank accepts financial successors as part of a promoter group. Okay. So we will take necessary actions in this respect.
I'm afraid, sir, the Bombay High Court order seems to offer a different view on that. They have said very clearly that, because of his demise, they don't become non-promoters.
The fact of the matter is that these are individual rights which were granted, and there is more to follow, so we'll see.
So it isn't said as, in fact, the Bombay High Court order says that the right to recommend under Article 110B is not and never was personal to either Ashok Kapoor or Rana Kapoor. It endures to each of their successors, legal representatives, and assigns. This right is not in the nature of a contract of personal service.
Well, if you see the interpretation of the Honorable Judge in this respect is very practical. He has really imbibed this case extremely well. He has recognized that the main issue is that the board of directors of this bank is substantially intact, right? The fact is that corporate democracy has prevailed year after year after year.
So I'll go back to the point you made. You said there was a modification required with regards to the Articles of Association. Therefore, I'm asking you if that's something that you're going to move in the near future.
Because there are, Manika, because there are certain elements of the articles that have become obsolete, and therefore the Honorable Court has encouraged the bank to refresh those articles. It's a very constructive recommendation.
And therefore, in connection to that, I'm asking you whether you intend to take away the promoters' rights to nominate directors on board.
Well, we will have consultations with the board of directors, and to the best of my knowledge, the board of directors will decide. Naturally, we'll go to shareholders and to Reserve Bank of India for any amendments we make, and then we'll come to CNBC in that sequence.
Well, that's lovely to hear, sir. You said there was another modification as well that's likely to be made. Can you elaborate on that, please?
So, for example, like whole-time directors, when the bank started in 2003-4, there were only 2-3 directors, right? At that time, naturally, promoters, myself, Ashok Kapoor, and Rabo as a co-promoter were the only 3 directors. So naturally, we were involved in every decision of the board. But as we have got institutionalized, please remember, there are 10 directors on Yes Bank's board. 7 are independent directors. And 2, our chairperson was an independent director. And the previous, chairperson, Mr. Srinivasan, is a leading regulator. And he is substantially independent as well. So you have a unique situation where 7 out of 10 are independent directors. 2 others considered non-independent are because...
If I may just ask you a quick follow-up question, sir. Mr. Srinivasan's position as chairman, has that been maintained in this order according to you? Because the reading of the order seems to indicate that his position of chairman, because of the appointment, is null and void.
Madam Doshi, Mr. Srinivasan is no longer the chairman.
I'm saying the appointment. I'm asking you if you still believe that the appointment was, in good faith or null and void.
Mr. Srinivasan has been elected on the bank's board again, a fresh election on the 6th of June. As I mentioned to you, the order is based on the AGM's 9th and 10th AGM. The 11th AGM was on 6th of June. The order was conceived on 4th of June. Mr. Srinivasan has been elected with an overwhelming majority.
So I'm simply asking you for your interpretation. His appointment, you are saying, is untouched by this order, right, sir?
Yes, madam. In the fact that he's been elected again on June 6th, only validates the fact that he's a fully elected director.
All right. Mr. Kapoor, we'll leave it there. We are at the end of this show.
And also know Ms. Radha Singh is the chairperson because your channel was stating that Mr. Srinivasan is the chairperson.
No, we didn't. We simply said his appointment as chairman was null and void. That's all.
Yeah.
We were referring to what the Bombay High Court's orders were in the decision.
Please remember, we've had 3 chairpersons after Mr. Ashok Kapoor's demise. Mr. S.L. Kapoor, who was chairperson for 4.5 years, Mr. Srinivasan, and now Ms. Radha Singh for the last, almost 7-8 months. And all of them have been
So that
elected.
could very well be the case. We are not disputing the facts. We are simply saying the order says his appointment as chairman was null and void. And that is written in simple English in the order, sir. We are not making any of this up. It is written all of there. It is also says in the order that any recommendations made by Rana Kapoor without the concurrence and consent of the plaintiffs, which is Madhu Kapur and Shagun Gogia, are ultra vires the articles and null and void. We were simply reflecting what the order says, sir.
Please also read that in conjunction with the Honorable Judge's statement that it is to be said the Professionals Bank of that necessarily means that it cannot run like a family estate. Please understand this.
We are not at all suggesting you run the bank as a family organization, sir. We're simply reading out what the order is. But
on the contrary,
we will let this be for another day, sir. We've come to the end of our time. The show is ended. You have given us the impression that this legal battle is over now, and there is no reason for it to continue here on. And on that note, we'll leave it there, sir.
Right, that's the conversation between Menka and Rana Kapoor of Yes Bank.